All right, we now call 25 CR 519, the state of Texas versus Joshua Guidry. That's you, sir?
Yes, sir.
Mr. Kimbler is here representing you. The state's attorney and probation is here. There is a first amended motion to revoke unadjudicated probation that is pending. It is filed as of January 28th of 2026. Are we ready to proceed today?
Well, I'll go ahead and interrupt, please, Your Honor.
All right, raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Does he waive a formal reading of this? Can we proceed in summary?
Wait for reading, proceeding summary.
In summary, this first amended motion to revoke probation alleges that on August 7th, 2025, in this criminal district court of Jefferson County, Texas, you were placed on deferred or unadjudicated probation for 10 years for the second-degree felony of assault on a peace officer. Is all of that true, sir?
Yes, sir.
First amended offense states, first amended portion of the motion to revoke probation allegations state that in number 8, you committed the offense of public intoxication on or about October 31st, 2025 in Jefferson County, Texas. Is that true or untrue?
True.
9, you failed to never become intoxicated or be under the influence of an intoxicating substance in that on or about October 31st, 2025, you were arrested for public intoxication. What happens is that public intoxication event, October 31st, apparently violates 2 conditions of probation at the same time. Committing an offense, public intoxication, and the requirement in your bond condition is your probation order was never to become intoxicated or be under the influence of an intoxicating substance. So is that allegation true as well?
I would say not true the way it's worded, Your Honor, since it's attempting to establish or assert that the arrest established the public intoxication, but I think he's already pulled true to being publicly intoxicated in the previous count. But I don't know if the arrest itself establishes public intoxication. Is that sworn in? So.
Okay, anything else?
No.
Your objection is overruled. The court will find the way we set up these conditions of probation that they are exclusive, but this court's practice has always been not to double punish for an event where 2 or more than one violation or crime can be carved out of an event, but it's in there.
He's pled guilty.
He's pled true. What happened on the first one? There was we had no hearing on that original.
That's correct, Judge. I don't think so.
Do we need to?
It's the same offenses, just a few of them.
No, you got phencyclidine in there.
Oh, there is that one test. Yes, Your Honor. We completed that.
Not to say that that's like one of the most, like the worst thing that's ever come out of a lab. Yeah, on allegation number 3, this states you illegally possessed a drug, phencyclidine, PCP, on or about October 10th, 2025 in Jefferson County, Texas, which would be a violation of your probation order. Is that true or untrue?
No, not true.
All right.
I think he had a positive UA from.
Okay. You ready to proceed on the PCP?
This was not a hearing, Judge. This was just an announcement. Is what it was set for this afternoon.
I thought
Mr. Kimbler just decided to go through and see what he put through.
Your Honor, please, I was going to see that bond.
We're going to look into the PCP. Every crime he commits, I want to know.
Yes, sir.
On my watch.
Just give me a couple weeks and we can do the PCP.
I'm going to sit for 2 weeks.
Request a bond on it.
Okay. Give it your best shot.
Well, I think it's deferred, isn't it? So he should be.
That's not a grant.
Well, I
release.
understand, Your Honor, but it's not. He hasn't been adjudicated guilty. It's the same status as the case from pending. So he will just request a reasonable entity bond as deferred status.
All right. Well, it's not debatable that he admits to public intoxication, which is a violation of his probation, and that's enough to grant the motion by a preponderance of the evidence or greater. And, no, I'm not going to grant him a bond until we can get to the bottom of all of this. But how quick can you be ready?
In 2 weeks, Judge. I just got to make sure I got
We'll
the
reset
ambulance
this
ready.
for 2 weeks and get it finalized. Tara, Faulkner.